Some leaders of the All Progressives Congress in Bayelsa State have congratulated the newly sworn-in President Bola Tinubu on his successful inauguration as the President of Nigeria. The leaders joined hundreds of APC supporters to watch the ceremony in Yenagoa. Joseph Kunde has details.
Hundreds of APC supporters turned up for a live view of the presidential inauguration at the party secretariat in Yenagoa. As the new president takes his oath of office, the crowd erupts into a joyous celebration, marking the dawn of the new administration with music and dancing. Party leaders are optimistic that the Bola Tinubu-led federal government will effect positive change across the nation.
On behalf of the teaming APC members in Bayelsa State, we want to warmly congratulate His Excellency Senator Bola Ahmed Tinubu and Shetima. We believe that Tinubu will bring the expected development, infrastructural development in Nigeria. And for Bayelsa State, when he came during the campaigns, he had assured the people of Bayelsa State that he has conquered the Atlantic Ocean in Lagos, and that our problem of the twin problem of flood and erosion that have troubled the Niger Delta for years will be conquered in his tenure.
Inauguration has taken place. The chairman has already mentioned the agenda, and we are waiting for the dividends of renewed hope, and we believe that it will be done.
The Bayelsa APC also expects the newly sworn-in president to address the economic and infrastructural issues plaguing the oil-rich Niger Delta region.
We expect ASUU Bola Ahmed Tinubu, the president, to address the issues of poverty, neglect, marginalization, and issues of the oil-producing areas. We in the Niger Delta, we want environmental remediation. We want ASUU to fund the NDDC more.
I know what God can do through my boss, Jagaban. People are saying all sorts of things, but me, I know that in the next 4 years, this Nigeria will be transformed.
While a lot is expected from the new president, attention now shifts to the appointment of a new executive council that will pilot the affairs of the country for the next 4 years. Joseph Kunde, TVC News, Yenagoa.
We'll return with more inauguration stories from other states, but let's turn our attention to Abuja, where the Presidential Election Petitions Court has adjourned the hearing of the petition of the Allied People's Movement to the 2nd of June. The adjournment is to give the petitioner time to acquire a certified true copy of the Supreme Court judgment delivered the 26th of May, which decided on the controversies around the double nomination of Kashim Shettima. This followed the submission of counsel to the President, Wole Olanikpekun, that the petition doesn't stand as the Supreme Court had laid to rest the sole issue the petitioner are asking for. The counsel for APM on these grounds urged the court for an adjournment to be able to look into the document and see how it affects their petition. And still talking about the courts, the National Industrial Court has held that it is legal to withhold salaries of striking members of the Academic Staff Union of Universities during the period which the strike lasted. Justice Benedict Kamping held that, in line with Section 43, subsection 1A of the Trade Union Act, members of ASUU who participated in the 8-month-long strike are not entitled to salaries. Although employers and workers can enter an agreement for which the workers will be paid during the period of the strike, when such agreement was not made, no worker is expected to get paid. Now, the court also held that the federal government cannot force ASUU to accept payments through IPPIS so long as they conform to their budgetary allocation. It adds the federal government was wrong to have imposed IPPIS on ASUU. The court also held that in line with Section 18 of the Trade Dispute Act, no employer shall embark on lockout and no worker shall embark on an industrial action when trade dispute is apprehended and a reconciliation ongoing. Now, Section 43, subsection 2 of the Trade Dispute Act, which gives sole powers to the minister to determine if there have been a lockout by an employer, the court notes, falls contrary to Section 6 of the Constitution. Well, we have our correspondent, Celestina Area, to help us better understand some of the rulings from the Presidential Election Petitions Court, as well as the National Industrial Court. Celestina, help us perhaps understand better what the Election Petitions Court is saying with regards to the APM, the case brought before it. Is it that the APM did not have the certified true copies while coming to the courts today, such that is seeking adjournment of the matter?
Well, Veronica, on the 26th of May, the Supreme Court delivered judgment on the issue of double nomination brought against now the Vice President, concerning which was brought by the PDP, saying it had double nomination. The issue was decided by the Apex Court and found out that there was no case of double nomination. But today, the Presidential Election Petitions Court resumed sitting after having its plenary session, that when the court adjourned to today to commence proper hearing for the petitioners being the Labour Party, the PDP, and the APM to open their defense today. So when the case of the APM was called up, counsel to the President, told the court that the APM's only grounds of filing that petition has been decided by a court of superior record, which is the Supreme Court. The APM's case was that of placeholder. They had alleged or argued that there's no such thing as a placeholder in our constitution or in our laws, that the manner at which the Vice President, as at that time elect, was selected by the President-elect as then was unknown to law, that there's no such thing as a placeholder, that Kebri Masari was used as a placeholder for Kassim Shettima. So the Supreme Court's issue was on double nomination, as to the fact that Kassim Shettima at that time was running for senator and also got nominated to be the Vice President. But Walola Bekun told the tribunal today that it is same issue and same matter. Although the APM did not quite agree, they said that they haven't gotten a copy of the document, that they will need to see the document to look at the issues if it's similar to their own issue, then before they will know how to proceed with their case. But let's also bear in mind that if they find out that that issue is similar and the Supreme Court has already decided on it, I believe they will be inclined to withdraw it. Otherwise, they will still want to proceed or pursue their case as they so please. Now, moving over to the National Industrial Court, which today has delivered judgment and has also said that no work, no pay in terms of ASUU members who participated in the long strike that started from February 14th up to when it was called off. And remember that that strike was called off by the court because ASUU and the federal government were having negotiations, were having meetings. The issue ASUU raised has to do with their salary increments, emoluments, and the use of UTAS against the federal government IPPIS. But at this very industrial court today, before now, the court has given ruling in an interlocutory application filed by the federal government ordering ASUU to return to the classroom. Ordinarily, they wouldn't have. But ASUU, as at that time, were very upset that they were having negotiations. The federal government came to the industrial court. But today, the industrial court found out that it is legal for the federal government not to pay ASUU for the period at which they went on strike. And the court backed that up with Section 43, subsection 1 of the Trade Dispute Act. And also looking at the ILO Convention, that is number 87, and other applicable jurisdictions, that the federal government should not pay ASUU and is legally binding. And the court also made reference to the fact that payments can be made if the employer and the workers had an agreement that, okay, during the period at which we would go on strike, you would be paid. But if such agreement was not made, no payment should be made.
I'm wondering the reactions we will be getting from ASUU with regards to this judgment coming from the National Industrial Court. But we must thank you, Judiciary Correspondent Celestina Area, for bringing us up to speed.